What fantastic remarks. It is my honor to invite to the stage next for our conversation. One of the things I love about thought leadership is that you get to explore the same topic, but from very different angles. So join us in welcoming to the stage partner at Freshfields and former DOJ litigation division head. Give me 1 second, guys. Having some difficulty here. Sometimes it's better to have paper. I'm learning. All right, please join me in welcoming to the stage Julie Elmer, partner at Freshfields and former DOJ, still not there, Antitrust Division counsel along with our speaker, Henry Liu, Director of Bureau of Competition at the Federal Trade Commission.
Hello, everybody.
Wow, nice to see a big crowd out here.
It is, from where I sit, the lights are exceptionally bright, so you all should feel very lucky.
Well, I'd like to introduce to you all Henry Liu. He is the director of the FTC's Bureau of Competition, and before that, he was a partner at the law firm of Covington and Burling. He has over 14 years of experience litigating complex antitrust cases, and he served as lead counsel both at the trial and the appellate levels. He also has a degree from Yale Law School, where he served on the Yale Law Journal. So please welcome Henry. I'm really looking forward to having a chat with him today.
Thanks for having me.
So Henry, it's really great to sit down with you and chat. We are really living through what I think is a very dynamic time in the competition space, and I'm sure it's been a very busy time for you as director of the FTC's Bureau of Competition. Could you share with us some of your top priorities as Bureau Director?
I would be very happy to, but first I want to say I appreciate not only you taking the time to speak with me, but thank you for inviting me to this conference. I have to give you my standard disclaimer that I speak, of course, on behalf of myself, not on behalf of the agency or the commission. It's the affectionately known as mistakes are your own disclaimer that all of us have to give. So when I think about my priorities for the FTC, I want to take a little bit of a step back and help you understand what the priorities are for the Bureau writ large and what we've been trying to achieve under the leadership of Chair Khan. I mean, it is really fascinating as I was looking at this agenda that it's an M&A conference, but the first three topics are antitrust. And lo and behold, antitrust, for all the antitrust lawyers out there, is pretty hot right now. And it's, I think, a reflection, at least from the agency's perspective, that we do have, in many segments of our economy, a market concentration problem, a corporate consolidation problem. There are companies that are getting bigger. There are smaller companies that are disappearing. And I mean, if you take just healthcare, for example, I don't think that even the most conservative economist would say that the healthcare markets are a bastion of perfect competition or healthy competition. And so the FTC on the antitrust side really is taking at heart that, number one, we, with limited resources, are really seeking to address root causes of market inefficiencies and absence of competition, not just symptoms. And second is to be forward-looking, both with respect to emerging technologies and new business practices and not trying to be stuck in sand in the present. So for me personally, and I've been in the role for about 8 months, so I barely know where my office is. You'll have to bear with me, but at a high level, I want to, in my time in the Bureau, have no regrets. And when I say that, just last week we had this really wonderfully nerdy antitrust conference, the spring meeting, for anybody who had the pleasure of attending. And I had the pleasure of hearing Executive Vice President Vestager speak at some point, and she said something to the effect of, if I knew then what I know now, I would have been bolder. And from my perspective, DG Comp has been plenty bold. And they've done a lot in this space. I suspect many of you all have interacted with DG Comp, and those who are outside counsel have probably engaged with them on a variety of regulatory matters, M&A matters under review. But I mean, I think that that is something that us as regulators, it is our statutory mandate to protect competition, and it's something that we are doing our best to take to heart. And it certainly doesn't mean that we're agnostic to both risk and to benefits of transactions. Far from it. It doesn't mean that all M&A deals are subject to antitrust review. But at the same time, it does mean that when the agencies conclude that there is a substantial risk of lessening of competition, that we are more inclined to act, notwithstanding that there are some residual risks associated with it.
And when you had been at the agency, I guess just for a handful of months, the agencies issued the new merger guidelines. In December of 2023, there was so much buzz around that. And do you think that the 2023 merger guidelines signal a change in the way that the agencies are looking at deals, or do you think that they reflect the way that agencies really have already been looking at deals?
Yeah, I mean, it really is a great question. I've gotten a version of this question multiple times, and from my perspective, it is very much the latter. The merger guidelines were not intended to create new law. They are, from the agency's perspective, I'm channeling our head of our Bureau of Economics here, he would say that they're the way the economists think about possibilities that a merger or a deal may harm competition. It's a checklist that an economist would walk through to determine whether there is a risk of lessening of competition. And so from the agencies, and most specifically from our staff's perspective, the guidelines really aren't a sea change in how the agencies think about a transaction. When staff gets an HSR filing and believes that there are some potential antitrust issues associated with it, that's the checklist they use. That's the one they've been using for some time for now. And we believe that it was time to give the market transparency into how agencies were thinking about potential risks to competition from a deal as the agency went through their merger review process. The one difference, which I'm not sure is a direct result of the guideline, but it is something that I think folks in this room should be aware of, is that we are at the agency increasingly focused on non-price dimensions of competition. And that's something that to me is fairly self-evident, but one that has been I don't want to say innovative, because that is one dimension of non-price competition, but it is something that I think has taken people by surprise. From our perspective, the statutory mandate of the agencies is to determine whether a deal may substantially lessen competition, and for whatever reason, price, because it's the easiest to measure, has been the principal determinant, the end-all, be-all of that assessment. And if a merger increases prices, that's a problem. If it doesn't, it's not a problem. But we now know in many markets, especially technology markets, there are zero-price products. And companies compete amongst a long range of dimensions, labor, of course, R&D, innovation, as you heard Olivier talk about, and agencies are thinking about those non-price dimensions in their merger review.
And does anything else stand out to you as being a specific or particular change in the 2023 guidelines as opposed to, say, the 2010, boy, that sounds like a long time ago now, horizontal merger guidelines?
It is funny. I was thinking about it on the way here. 14 years, to my mind, is a long time between guidance for the market about how the antitrust regulators are thinking about merger review. 2010, I think, was Apple iPhone 2.0, and now, obviously, technology markets generally are very different. Just wait till we get to the HSR forum. It's been even longer since we've made a change there. The one other major change I want to highlight, and again, it stems from the real intense focus in the agency's merger review on the lessening of competition, not necessarily outcomes, increased prices. And one thing that I spoke about last week during the spring meeting was in our merger review cases, for those of you all who have had the pleasure of either advising companies or litigating companies, I think folks may be familiar with this esoteric concept of market definition. I don't know if that rings a bell to folks in this room, but there is, in merger litigation, an increased focus on defining what is the area of effective competition. There are economic models associated with it, and there's lots of money, time, economists, and effort spent in this exercise. And one thing about the 2023 guidelines that we wanted to make clear is, look, we should return to the more common sense approach for evaluating whether a merger threatens competition. And if two companies are very close competitors, they are going after each other in new products, innovation, price discounts, promotions, et cetera. You don't need to go through this esoteric economic exercise. You can determine, based on the closeness of competition, that the merger may have harms to consumers. So I think that is an example of how we're trying to make our assessment more transparent for companies and for outside counsel as they engage with staff during our review.
Do you think that the agencies will be bringing any cases that are based more on this evidence that you see in the business documents of head-to-head competition, for example, but without going through what you said is sort of the esoteric process of defining the market? Do you think that's going to happen sometime on your watch, for example?
I will say this. The agencies already have and certainly will continue to say that regardless of what you think of as the market, product market, geographic market, that if you have direct evidence that two companies are close competitors, that's a deal that really threatens consumers. And there's a bit of a self-evident proposition behind that. I know I'm not directly answering your question, so I'll get to it. But I mean, I just think about, like, if you take a really obvious example of like Nike and Reebok merging, and stay with my crude analogy, it's a very weird exercise to think about that in the concept of like trying to figure out, well, shoes, sandals, what about athletic wear, what about dress shoes, et cetera, et cetera. I think that most people start with the assumption of, yeah, those two companies are pretty close competitors. They are often substitutes for one another in consumers when they're purchasing certain types of shoes. And that when a court is evaluating that kind of merger, you don't need to go the extra step of figuring out what else is out there. You just sort of know based on the direct indicators that there is some type of competition problem. And so to answer your question more specifically, I can't imagine a scenario in which we have conceded that there is no relevant market and we're bringing a case based on closeness of competition, but we certainly are advocating to courts and continue to believe we will, that if a court believes that two companies, there's some real indication, whether it be third parties or documents, that there is a closeness of competition, that's a reason alone to find the transaction to be unlawful.
And do you think that there's anything in these new merger guidelines that technology companies in particular should be aware of as they contemplate engaging in transactions?
I mean, it's a great question. I'll list two briefly. One is, I spoke earlier about non-price dimensions of competition. And many of you all know we have a pending case challenging Meta's acquisition of WhatsApp and Instagram. And one argument the agency we have advanced in the litigations that at issue is that absent those transactions, it would have resulted in greater improvements on privacy dimensions, privacy protections for consumers. And so I think as you all are doing deals and advising companies in the technology markets about antitrust risks, other non-price dimensions of competition will be important to staff, will be important to the agency, and that's something that we hope we will engage with you on. The other, I'll just echo Olivier, is we are thinking about potential competition. And you all heard the term killer acquisitions. And the general notion is that if you have a company with market power and it acquires a small startup company that it believes could develop in the future into a competitor, that's a problem. And that's, we have had a couple of cases in the last 12 months that have focused on that as a theory. We see that as an issue in technology markets, and I do think that that's an area we'll be continuing to focus on.
That's really helpful insight. I do want to shift gears a little bit because another hot topic of discussion, and I think you alluded to it earlier, were potential changes to the HSR form. And I understand that the agencies have received many, many comments about the proposed form, and I'm wondering whether you have any updates that you could share today.
I'll share the same update I shared last week, which is that the agency has spent a lot of time reviewing the comments that were submitted on the HSR form revision, and we expect a final form to be presented to our commission for a vote in the near future. A matter of weeks, not months, I'll put it that way. I will say that I think folks will be surprised at how serious the agencies took the comments, the potential burden issues, and how those comments have been incorporated into the final product that will be presented to the commission for a vote. I will also just say, because you mentioned comments, something that is very asymmetric with the HSR form, which is the following. It has been, from the very start, an intensely staff-driven process. I think if you polled DOJ antitrust staff and FTC antitrust staff that do merger review, how popular the HSR form revisions are, it would be 100 out of 100. It is overwhelmingly popular. The ideas for the form came from them, and that's in part because they have you remember this from your days at DOJ, there's a deluge of filings that managers need to get through, and the current form, from their perspective, is just not enough for them to make a real determination on a number of deals about whether there's a potential competition issue. And so then there's all sorts of voluntary access letters, pull and refiles. Everybody in this room knows how the agencies try to figure out whether there's a there, and the new form, in our humble opinion, is an effort to streamline that process, streamline second requests, and ultimately reduce the number of second requests that are issued by giving the agencies more information up front.
Well, we look forward to seeing the new form, and it's just really helpful to hear how the agencies have been responding.
I will just, I made a joke earlier, I think the last form revision was 45 years ago. And I'll just put myself in that. It was before I was born. And I suspect a lot, I don't know, was anybody practicing 45 years ago? Okay. I see a hand or two maybe, but not many. I mean, transactions really have changed substantially in the past 45 years, and the amount of information, the deal size, everything under the sun. And I do think just putting that in context is helpful to understand why we felt that now was the time for a change. And I do recognize that there were a lot of comments about particular changes that were burdensome on companies. I'm hopeful that the agency's process has resulted in a final product that balances those concerns against the agency's interest.
So another topic that was I think, talked about quite a bit at last week's spring meeting of the Antitrust Bar in Washington was the subject of international convergence and collaboration in the antitrust space. And my question for you is whether you've seen any uptick in international collaboration over the last couple of years.
It was another hot topic during last week's spring meeting, and what I'll observe is, I first want to say our international dialogue is run out of our fantastic attorneys in our Office of International Affairs. And they have tremendous relationships with competition authorities across the globe. And the ideas that flow between the competition authorities has really been tremendous over the last few years. I think there has been a convergence, principled convergence of many competition authorities around the world that corporate consolidation in many sectors of the economy are becoming increasingly problematic. And I was listening to Olivier's comments. I think a lot of his observations on technology markets, the US regulators share, CMA shares, and other agencies share. And so I think that because of the similar concerns, we obviously operate under very different statutory regimes, very different regulatory regimes. Judicial review is very different. But I think the core concerns from a lot of the regulators are increasingly common. And so as a result of that, I think there is an increased opportunity for collaboration amongst international competition authorities.
So switching gears a little bit, maybe to the more practical side of things, what are some ways in which parties to a transaction that are facing potential antitrust scrutiny can prepare to engage effectively with the agencies?
My time at the agency has been limited for a few months, as you know. What I would say is that the outside counsel that have come to speak to me, our management, about transactions have overwhelmingly been credible, courteous, and I applaud the vast majority of folks who have come to our office and advocated on behalf of their clients for certain deals. And I can guarantee reciprocally that, and I hope they would say in those meetings, we treat them with great respect and we listen to their arguments very seriously and we consider them, we always huddle and really think about them hard and determine where we think they have good points, where we find the evidence less persuasive. What I would say is a very obvious comment is that I said vast majority. That means that they're not all outside counsel have come to us and been credible. And obviously, there's a demeanor aspect to that. I know you know this in your time at DOJ. But there also is an objectivity. I think it's really important for you all to know that we are persuadable. We are persuadable. We're an agency of limited resources. The size of the Bureau of Competition is about 400 staff and attorneys. That's smaller probably than Freshfield's litigation department. We can't review every deal, and we can't look under every rock. And so we are eminently persuadable. But when folks come in and treat us like courts or juries to be advocated in front of, where they do not acknowledge the ordinary course documents, the weakness in their case, where they say there's nothing to see there, that chat, that document, that data, don't worry about that, it really makes our job a lot harder because it makes us less receptive to the overall presentation and advocacy. It's a really self-evident proposition, but when outside counsel comes in and say, look, I know you're concerned about these documents, we are too. But here's why ultimately we think that this deal is not a problem for competition, entry is easy, whatever other arguments there are. To me, that's a very effective presentation.
That's very helpful. Do you have any other suggestions for parties that are looking to engage effectively with the agencies on remedies? How can they improve their ability to engage on remedies?
Yes, litigating the fix is a big topic these days in the antitrust field. Let me just say at the top level, and I hope folks can understand this. I mean, the statutory mission of the two antitrust agencies is to determine whether deals are illegal because they may substantially lessen competition. We are certainly not in the business of trying to create deals and fix deals. And so part of the remedy discussion is it is, at least in part, beyond our principal mandate. And there's an empirical part of that, why we believe that is because the history of remedies, at least in certain markets, hasn't been great. I can acknowledge that about our own agency. We've had a number of remedies that have had significant execution risks over the last 15 years and have not succeeded. And obviously, the impact to consumers and competition in those instances is significant. So, we start with the top line of, we, of course, are always willing to listen. We have accepted remedies. Late last year, we agreed to a consent in the Amgen Horizon case, for example. There are other examples where we're agreeing to consents and remedies, but we're presumptively skeptical of remedies in part because we're not well positioned to evaluate execution risk as well as what that world would look like with a antitrust counsel created business. So let me stop there, and if you have any other more specific questions about how we're thinking about remedies, I'm happy to answer it.
I think you provided a good overview, and we've hit on a lot of the topics today that I think have been sort of hot button topics in the antitrust press. But are there other issues that maybe haven't gotten a lot of airtime in the wider press, but that you think that parties should be thinking about more when they engage with the agencies? Maybe some things that are flying under the radar a little bit more.
Well, I would say at a high level, and I suspect many of you all would agree, not much is flying under the radar with the FTC these days. But two, I would say, more counsel-focused points that I'll flag for you all. One is we had a blog post about ephemeral messaging recently. That is a big deal for both agencies. It is going to be a presumptively required element of second requests and something we're thinking about very carefully in our merger review. I know you all are thinking about that deeply, not just in the antitrust context, but in compliance and private litigation and everything else under the sun. But of course, it is something that you will expect to engage with staff about. So I thought I'd mention that. The other is, since you raised the question of international cooperation earlier, we have had instances, not common, but instances recently in which companies have refused to provide waivers. And to give this room a bit of context for those non-antitrust practitioners, we typically request the companies, we request the company's consent to share information and coordinate and collaborate with international competition authorities. And of course, it's voluntary. So we are not, of course, we are very much certainly not saying that companies have to give us waivers. But we have found that in some instances, companies are using waivers as a bargaining tool, as a weapon. We will agree to give you more time. We will agree to a waiver if you agree, X, Y, and Z to, eliminate certain second request productions. And to us, that is troubling. It is something that, from our perspective, when a company doesn't want us to collaborate and cooperate with international enforcement agency, it raises, suspicion is not the right word, but it raises questions about whether there is underlying antitrust concerns in one jurisdiction or another that the company is concerned about. And so I guess I would encourage folks, to the extent that there isn't a tactical reason to do so, waivers from our perspective are a very helpful and efficient way to get to the right result.
So another topic that early on in the Biden administration, I remember hearing about was sort of this whole of government approach to competition issues. And I'm wondering if you've seen during your time at the FTC any increased collaboration between the competition agencies and other domestic agencies here in the United States.
Yes, there was a meeting at the FTC, an Enforcers Summit, a week ago, last Monday, where several non-competition agencies came and spoke about their competition agenda and their priorities. And there was a great line from the chair of the SEC, Gary Gensler, where he said, I'm paraphrasing, something to the effect of, well, one effect of the Biden executive order is that we're now competing against other agencies because we have to meet every once in a while and report, what have we accomplished on the competition agenda? And so everyone's, every 6 months, what did we do? And he joked a bit, but it has been true that one real upshot of bringing everyone together on competition issues across the government is that there is an expectation and accountability that agencies are thinking about that even when antitrust is not their principal mandate, whether it be the Surface Transportation Board, the SEC, the CFPB, and the like. And that was a common theme in the summit we had last Monday. On how it's affected us in practice, what I would say is that we have always cooperated with other agencies, but there has been a significant uptick in that very recently. As you all know, in reviewing defense mergers, we cooperate very closely with the Department of Defense. But we recently signed a memorandum of understanding with the Department of Labor. It is well known that the FTC and the DOJ are focused on competition for labor and how either merger or conduct may affect salaries and benefits for workers. And the MOU we have with the Department of Labor helps facilitate information sharing to better get at those labor competition issues. We are closely collaborating with HHS on a number of fronts. We, DOJ and HHS, have an information sharing agreement that is an effort to better allow us to detect sub-HSR, non-reportable deals that may raise competition issues. And we recently held a workshop with HHS and DOJ about the role of private equity in healthcare. And the hope is that that effort will bring public information into our collective agencies' orbit to better understand how PE acquisitions and investments could affect competition in the healthcare space. So those are just a couple of examples, but I do think that the executive order and President Biden's focus on antitrust has increased the agency's collaboration on a number of metrics.
And speaking of labor issues, I read yesterday that the commission is going to be voting on a proposed final rule that would ban most non-compete agreements. Do you have any details or sort of any overview that you could share with the group today about that?
For those that don't know, I'll report what is been reported publicly. There is a commission meeting scheduled next week where the commission will vote on whether to approve the final rule on the non-competes ban. I can't disclose the content of what the final rule is until it's made public, and obviously the vote will be up to the commission. But subject to the commission vote, it will be finalized, if the commission votes it out, finalized shortly thereafter.
Well, I think we're about at time. It has been a great pleasure to sit down and chat with you today, Henry.
Thank you, Julie. I appreciate you hosting, and thank you all for listening.